On the record in the matter of Copper Bay Company LLC versus Jamie Jenkins, Michael Jenkins, Linda Hayes, and Terry Hayes, file number 22-03109 LTE, council appearance.
Good morning, Your Honor. Jeffrey Ray on behalf of the plaintiff.
Do we have any? Okay, this is scheduled for a motion, but it doesn't tell you the type of motion. I do see in the file a motion to amend money judgment. There's a note from civil. I think the issue that they highlight was that it says sign attached order, but there was nothing attached. I'm not quite sure why this was set for a hearing, but I guess it gives it gave the parties an opportunity to appear and object, and they've not appeared. So your motion to amend the money judgment, which you highlight in your motion, the damages including unpaid rents, and you outline that, and you're seeking to amend the money judgment to a principal sum of $25,675.30 with costs and statutory attorney fees. Is that correct?
Yes, but I didn't realize we exceeded the jurisdictional limit. So when we submit the judgment, we'll cap it at 25.
Thank you. Okay, we'll look forward to your judgment in order. You can submit that under the 7-day rule.
Thank you, Your Honor.
Thank you. You're all set.
Thanks.
We're on the record in the matter of Sycamore Town Homes versus Clifford Lofton. File number is 23-00101 LT. Council appearance.
Good morning, Your Honor. Jeremy Piper, P63008 on behalf of the plaintiff.
You, Mr. Lofton?
Yes, that's me.
Okay, today's the date and the time that's set for a motion.
Yes, Your Honor. We had a chance to talk in a breakout room
Wait,
and
just a moment, because his phone was ringing. Turn your phone off, please. Okay, so today was the date and time set for a motion to set aside default. Counsel, you stated that you all met privately.
yes, Your Honor. And what we are requesting both parties, there's an outstanding work order that is going to be handled tomorrow. And we'd like a short adjournment, and hopefully the matter will be resolved by the next time we're in court.
What matter of the default?
Well, the default would remain pending the next hearing, which would be an adjourned hearing on the motion to set aside.
Okay, well, why would I not address the motion to set aside default today? Because you have a outstanding work order. What is the outstanding work order for? What is the outstanding work order for?
Your Honor, I don't know the specifics of it. I just know that there was an issue with access to the unit to address it. The manager's on the Zoom and can explain the details of the work order, but the maintenance people were not provided access.
Client was supposed to do at the property, then, correct?
It's work that the defendant has requested to be done, yes.
Okay, when was the request made for the work to be done?
I don't have that information. I could ask my client who's on the Zoom.
When did you make a request for the work to be done?
Ma'am, I made that request in October.
October of 2022?
Yes.
Okay, okay, so you were scheduled to be in court, it looks like, May 10th, you failed to appear. There was a default judgment. You filed a motion to set aside default judgment on the 22nd. Let's see. You state that you were ill during the time of the hearing, that you were physically sick and depressed, and you got your days backwards, missed the hearing. That says you're seeking therapy, is that correct?
Yes, I'm getting it. Yeah.
Okay, entire apartment complex. The property is pink tagged.
Everybody's property is pink tagged.
When was the property pink tagged?
2 weeks ago. Everybody's property, not just mine.
What's the exact date that it was pink tagged?
The exact date, I'm sorry, I just don't know, but I went to the office downstairs to get that information. They said that office is in another building down the street going north. So I have to go to another building to the code, it's called code compliance, to get a copy of the tag and the date that they did it.
Okay. I'll grant your motion to set aside the default. We'll set it for another hearing.
Your Honor, will we be setting that date today or will we get it from the clerk?
June 21st, at what time? 3:15.
Thank you, Your Honor.
No problem. Do you have any questions today, sir?
No.
Okay, we'll get you a copy of your notice to appear. You can have a seat.
Mr. Lofton, that work will still go ahead as scheduled tomorrow.
Okay, thank you.
Thank you.
Thank you. You're all set. Did you do an intake with legal services when you were here before? Mr. Lofton, did you do an intake with legal services,
Legal services.
legal aid?
I think we did it on the phone, yeah.
He's all set.
Did he get a copy of this notice? Yes.
Thank you.
Mr. Piper, I think you're all set unless you have another matter.
No, that's it, Your Honor. Thank you very much.
Thank you. they complete a joint pretrial statement?
Sounds like there's been issues like we're.
On the record in the matter of Grand Ledge. Okay, we're on the record in the matter of Grand Ledge Emergency versus Terry Sibley. File number is 23-00618, council appearance.
Good morning, Your Honor. Robert 5670, appearing on behalf of plaintiff.
You're Mr. Terry Sibley? Okay, today's the date and the time that was set for a civil pretrial. Did you complete a joint pretrial statement?
Your Honor, plaintiff, we were here on May 3rd. We talked in a breakout room. I had emailed Mr. Sibley, or my law partner had emailed Mr. Sibley a copy of a proposed pretrial statement. We never received it back. We called, never got response. So we sent in a statement to the court, signed by plaintiff, but not by Mr. Sibley. We talked in a breakout room this morning. He doesn't see the email that was sent. I've confirmed that the email address we have is accurate. We're hoping to just get it signed today. It's straightforward proposed pretrial statement. We're asking for 60 days discovery. This is a $970 case.
What's the problem with the joint pretrial statement?
I didn't receive the email. I checked it. They said they sent it.
Okay. Can you send it to Judge Simmons Courtroom at lansingmi.gov?
Judge, we've already mailed the court. When we didn't get it back from him, we've already sent it to the court. There should be a copy in your court file. I believe we actually emailed it. There is or is not.
They did not put a copy in my court file.
All right, we did email it to you on May 19th. We emailed the office Nicole Bigelow. Or Nicholas Bigelow. Nicholas Bigelow, yes. Nicholas.bigelow@landmi.gov.
Okay, so you confirmed your email address with the plaintiff, and it was the correct email address? Okay, and you still allege you did not receive it?
I did not receive it.
Okay, I have a copy of the joint pretrial statement. You can print a copy for him, Mr. Bigelow. I'm sorry? What is this? What is that? I can't see that.
Statement and definition.
What is that?
They mailed it to me.
No, that's not, this should be a joint pretrial statement. It should say joint pretrial statement on it. Okay, you can just give him that. We don't have time for him to go through that right now. That's a joint pretrial statement. I want you to review it and tell me what you dispute about it. Because they left you phone messages and you were supposed to get back to them. We were here almost a month ago. This should have been taken care of already.
I don't have no voicemails from them.
Well, you were here in court and you all
Yes.
represented to the court that you were gonna get it taken care of. So it was your responsibility to do that.
Oh, I got some and I emailed somebody and they told me no, I had to wait for something else. The day of, I emailed back, I said, this is what I've been looking at.
It says the issues with the defendant breach or break contract for failing to pay for medical services. Pretty straightforward. Other issues is the amount owed by defendant and whether or not the defendant is liable for medical services provided. Pleading satisfactory, they say yes. I don't see any reason why the pleadings are not satisfactory. Do you know what a pleading is? Pleadings are the paperwork that's been filed, the complaint. You've not filed any pleading. Well, I guess you filed an answer. They did not object to the form of your answer. And you've not objected to the form of their pleading. So the pleadings are satisfactory at this point. Motions that are anticipated to be filed will be motions for summary disposition, motion to compel discovery, and or a motion to compel more definite responses to discovery. And those should be filed and heard by August 3rd of 2023. You have any questions about that? Okay, consolidation, there, it says no, that means there's no other cases that we need to consolidate with this one. And unless I'm missing something. Is there another pending case that involves this? Okay, admission of facts, neither party is admitting any facts. Exhibits. Any and all records of defendant's insurance company. It's gonna be any relevant documents, because that could be a lot of records. So I'll note that too. Any and all relevant records. Any and all correspondence between the defendant and plaintiff relative to the issue before the court. Any and all exhibits identified on defendant's exhibit list. Any and all rebuttal exhibits, plaintiff reserves the right to identify additional exhibits as they become known. Or we'll say plaintiff and defense. Discovery is open for 60 days. Do you know what discovery is, sir? So that's your time in which you can ask for this information that you need to defend your case. So if you need records from the insurance company or anything to that nature, you can file a request that must comport with the court rules. It's apparent to me that you need to familiarize yourself with the court rules because you're representing yourself in this matter. And you don't know what any of these things are. You have to recognize that. So you have to get a copy of the court rules, or you can Google the Michigan Court Rules for Civil Procedure, so you can know what these things are and how you can properly comply with them if you're going to defend yourself, okay? Expert witnesses, none. I don't see why the plaintiff would need one. Do you believe you would need an expert witness? Expert witness is not a lay witness. So a lay witness would be if you needed to call, someone who could witness whether or not you actually went to the doctor, that sort of thing. An expert witness needs to have a special qualification. You understand that? Okay, you foresee yourself needing an expert witness in this situation? No, ma'am. Okay, I didn't either, but I wanted to give you the opportunity. Plaintiff is seeking money judgment in the amount of $972.25 plus recovery costs and interest. There's no joinder of claims. Let's see here. Okay. We do not have a jury demand, so this would be a non-jury trial. Discovery. This discovery is open for 60 days. You need 30 days after that to file motions. I'm gonna construe discovery to be open for 60 days from today's date. So I'm gonna change the motions to be filed and heard by September 3rd instead of August 3rd. And then trial will be set for a time after September 3rd. Settlement has been discussed and defendant maintains his position and that he should not be liable for damages. It's accurate, sir. Other parties the parties have agreed to exchange documents via email. I don't know if that works because it sounds like you're not getting your emails from them.
We'll both ways, Judge, first class mail as well as email.
Thank you. Do you have any other, a case evaluation, they say no, and mediation, they say no, so you all just want to proceed to a trial on this if it's not resolved via motion for summary judgment, correct?
Correct.
Okay. Do you have any questions about this document at all?
It's a simple fact that they never mentioned anything about her asking me that I want to use the ambulance service, and I told her no.
Well, I asked you if you have any questions about the joint pretrial statement. They wouldn't put that in the joint pretrial statement.
Yeah.
Yeah, this is how we get a scheduling order.
Oh,
This is not how we figure out what your defense to anything is,
Alright.
okay? So that will come in at a time of a trial, or if they file a motion for summary, you would need to respond to that. And then you could put your defense in there. You need to make sure that you're paying attention to your mail and or email, because you're gonna, these deadlines that we're just talking about, if you miss something via email and they file a motion and you don't respond, then they get a default judgment, which makes you automatically liable. Do you understand that? So you gotta make sure you're staying on top of your mail and don't forget about this pending action, okay? So if you have any other questions about this joint pretrial statement?
they have my number. Like they said, they called. I know I don't have no voicemail. I was on my phone.
Right.
I got the mail. I did not get. He literally asked me and he told me exactly what day it was. I served back to my email. I have nothing from nobody.
Okay, well, it sounds like they're still going to serve you by first class mail,
Yes.
and your address has not changed. If it does change, it's your responsibility to notify them. You recognize that?
Yes, ma'am.
Okay, I'm gonna give you that copy because that's the copy I made the changes on. And if you don't have any disputes to that, then you need to sign that and then I can sign it.
Thank you, Your Honor.
Thank you. Any additional matters for the record?
From the plaintiff.
Do you have any other issues, sir?
No, ma'am.
Okay.
Oh, shit.
Yeah, I've signed it. We'll get you a copy of this for your records, okay? Okay, you're all set. Thank you.
Yeah.
On the record in the matter of Hunter. I'm sorry, let me do this one first. Let's see, we're on the record in the matter of Kurt Civilette versus Matt Guerrero and Crystal Guerrero. File number is 23-00389 LT. Council appearance.
Good morning, Your Honor. Nicholas Darlinghouse, number 72150, on behalf of plaintiff Civilette.
Okay, and Mr. and Mrs. Guerrero are present. Do you have an attorney at all representing you today? Okay, today's the date and the time that was set for a non-jury trial. Are you ready to proceed?
Yes, Your Honor.
Okay, any preliminary matters before we proceed?
Your Honor, we had submitted a few exhibits for but I can just have them entered during testimony.
You submitted them how?
By first class mail to the defendants and then email to Mr. Bigelow.
Okay, yep, you can have them admitted as you go.
We also emailed evidence on our behalf. I was a day late. We've seen the email and we have all with us. We have the conversations with us and the landlord.
Okay, so you have your evidence with you, correct?
Yes.
Okay, sounds good. Any other preliminary matters?
I don't believe so, Your Honor.
Proceed.
Thank you, Your Honor. This is just pretty straightforward, I believe, non-payment of rent case. And for the property located at 1009 West Ionia, apartment 2. My client as the owner and the Guerreros seeking possession only, no money judgment at this time. And I guess for my first witness, I would just call Mr. Civilette.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes.
You can have a seat, sir. Okay, I'm gonna give you a couple of rules. There's a microphone that's in front of you, and the lady behind you is my court recorder. She has to take down everything being stated here today, so your responses need to be verbal and they need to be loud and clear, okay? So they can't be mm-hms, uh-huhs, or head nods and head shakes, because she can't write that accurately into the record. If there's an objection made by any of the parties, you would stop your speaking. I will make a ruling on that objection, and then I will let you know whether or not you can give that response or not, okay? Okay. Please state your first and last name, spell both of them.
First, Civilette.
You can proceed, or I need you to spell them both.
Oh. K-U-R-T. Last name is Civilette.
You can proceed, counsel.
Thank you, Your Honor. All right, Mr. Civilette, are you the owner of the property at 1009 West Ionia?
Yes.
Here in Lansing? It's here in Lansing?
Yes, I am.
Okay. All right, and did you rent out, well, it looks like this is a multi-unit building, is that correct?
Correct, it's a duplex.
Objection.
What's the objection?
I don't believe it's a multi-unit. I don't believe it's able to be filed that way. There is one thermostat that controls the heat throughout the entire house. We did not have control of it unless we had.
Okay, so you're
Wi-Fi.
disputing what he's saying, correct?
Yes. I
Okay,
don't
so if you
think-
have a dispute, then you wouldn't object to that, because that
Oh,
you,
sorry.
what you would do is you'll note that. You have something to write on?
I can bring up.
No, we'll get you a pencil and paper. You need to
Thank you.
have pencil
Yeah.
and paper. You need to note, because what's gonna happen is he's giving testimony, then you'll give you'll have an opportunity to cross-examine him. Then you'll also later have an opportunity to give testimony, and then he can cross-examine you.
Okay.
You can do one of two things. You can address what your dispute is when you give your testimony, or you can cross-examine him and that after he's finished giving his direct exam, and see if you can get that information out of him,
Did
okay?
I hear correctly that they just want possession? They're not asking for a money judgment?
That's what they said.
You did hear correctly. That's all we've been seeking.
Did you want to talk about that first before you get to this point, or before we move on?
Well, we found a place. to-
Okay, off the record, you all have to go talk.
Okay, thank you, Your Honor.
I think that.
Well, I don't want,
Everything.
yeah, you should talk to them privately. Don't let me be privy. Mr. No, he's not on the next one. It's Mr. Levine. Which matter are you here on, sir? Sir?
Oh, good morning, Judge.
Good morning, you're here on the 2930 matters.
Yes, I'm here on the 200 Town Homes.
Okay, Eric Bramer is on Zoom. I do not see Letitia Moss. On the record, in the matter of Huntertown Properties LLC versus Letitia Moss, file number is 22-04303 LTE, council appearance.
Good morning, Judge. For the record, Brent Ingram on behalf of the plaintiffs.
Okay, today was the date and the time that was set for a trial on a landlord tenant matter. This matter was scheduled for trial at 9:30. It's currently 9:39. And no one has appeared on behalf of Letitia Moss. How would you like to proceed, counsel?
At this time, we would ask for a default judgment to enter, Your Honor. Currently, the rent to retain this matter is $7,663.10. Court cost is $167.50. Total redemptive amount is $7,830.60. We would ask the writ to issue in 10 days.
Default judgment is granted as stated. Writ will issue in 10 days.
Thank you, Judge.
Thank you.
We'll submit that later.
Yes, thank you. Oh, did you speak to Mr. Bramer already?
Pardon me?
Did you have an opportunity to speak to Mr. Bramer to see if you can
I did not, Judge.
resolve anything? Okay, are you able to get on Zoom?
I'm sorry.
Are you able to log into Zoom?
I could, I guess, on my phone.
You have an iPad if you don't.
Something back there.
Yes, right there.
Yeah, it'll work.
On the record in the matter of Kurt Civilette versus Matt and Crystal Guerrero, file number 23-00389. The parties went off the record to see if they can further negotiate. And I have here a consent order for conditional dismissal. That's correct.
Yes, Your Honor.
States here that the parties are agreeing that the defendants will vacate the property or the premise by the end of the day, June 12th, 2023. That's accurate?
Yes, she gets paid the 9th, and it's gonna be close. We're gonna order the moving company, as long as we are gonna have cops showing up on that day to get us out, I think we'll be just fine. I think that we'll be able to, we're gonna have a $1,200 check. Right?
Yeah.
Yeah, and that should be able to get us out of there. And we thought he was asking for money, the whole, like the rest, the whole rent too.
Okay.
And we didn't have this secured until this apartment secured until now. The market is completely messed up.
I recognize that. So this is, you're agreeing that you can vacate by the 12th though, correct?
Yeah, we secured this
You
apartment.
said it was close. That's, you sure that the 12th is a good date?
You wanna make it like the 14th, just to be sure, like
I'm offering.
yeah, go ahead.
Okay, Your Honor, we'd like to stick with the 12th, based on the discussion that we had out there. I don't, I've assured the tenants that the court officers would not be out on that date, because that would be impossible.
Okay.
The way it works is you agree by the 12th. If you don't vacate by the 12th, they can file a motion with the court on the 12th.
Oh, yeah.
And then get an order or for a writ of execution. Once they get that writ, then they can schedule to have you forcibly removed from the property.
Yes.
But you would have to understand that you need to vacate by the 12th. That's what you're agreeing to?
Yes, I think that's really possible.
Okay, and partial performance will not satisfy this. You have to have all your stuff out of the property. You can't leave trash there, some of your stuff that you'll come back later, some of the furniture that you don't want. You need to leave this property in broom swept condition. Do you understand that? And then you should take pictures and or schedule a walkthrough on that date so that you CYA cover yourself. You understand that?
Yeah, because you can charge us for cleaners to come in there, clean up after us, like. Sure.
Okay, all right. Anybody forcing you to waive your hearing today or your other rights in order for you to enter into this agreement?
No, I don't think so.
Any promises being made to you, not stating here on the record?
No.
Okay,
We're excited to move out too, because like I said, it cost us arm and a leg to cool that place all summer because the broken windows and the lack of insulation. It really needs to be remodeled.
sounds good. I'll sign and date this for today. I'll also give you 3 business days from today. If you leave here today and realize you misunderstood any of the rights that you're waiving in order to enter into this conditional dismissal, that is, you can request to have this dismissal set aside within 3 business days, and we'll proceed with your trial, okay? So that, again, those rights would be your right to the trial and also your right to be represented by counsel, but you have continuously waived that right at this time. Do you have any questions? Any additional matters for the record, counsel?
No, Your Honor.
Thank you. You're all set. All right. We're on the record. In the matter of Huntertown Properties versus Eric Bramer, file number 22-04299 LT, council appearance.
Ron Tinkham on behalf of the plaintiff.
Was the date set for a bench trial? My understanding is that the parties have come to a resolution.
That's correct, Your Honor. We are going to be submitting a conditional dismissal. Terms will be as follows: that the defendant shall vacate no later than June 12th, 2023, or alternatively pay the amount owing of $11,141.44, which is $10,973.94 of rent to retain and $167.50 of court cost.
Mr. Bramer, is that a complete and accurate understanding as to how you want to proceed today?
Yes, it is the best option available to us, and I accept it. Thank you.
Okay, very good. Do you understand that you have the right to be represented by an attorney at this proceeding today?
Yes, I do understand.
Okay, and you're waiving your right to representation?
Yes, I am.
Okay, and you also have the right to proceed to a trial. You were scheduled for a non-jury trial today. You're waiving your right to have a non-jury trial in order to enter into a conditional dismissal with the terms stated on the record?
Correct, yes.
Okay, very good. You understand that partial performance will not satisfy this conditional dismissal, so you need to either vacate by June 12th, meaning you're taking all of your personal items and you're leaving that property in broom swept condition. You understand that?
Stand.
Or you're paying the amount remaining that's due that was stated on the record. You understand that?
I understand.
Okay. Anybody forcing you or making any promises to you to get you to entering into this agreement?
No one is making any kind of force upon me. It is my decision to leave as according to this agreement.
Okay. Thank you. And you are giving a council permission to sign your name to the agreement?
This agreement, yes, I am.
Okay, very good. You have 3 business days from today. If you leave here and realize you misunderstood any of the rights that you just waived in order to enter into this conditional dismissal, you can return to the court and file a motion, and we'll reset this for a hearing, okay?
Thank you.
Do you have any questions for the court at this time?
Questions at this time?
Okay, you're all set. Thank you, sir.
Thank you, Judge.
Thank you.